Hey everybody, it's Elektra Yao, artist, visa lawyer, and entertainment lawyer. I'm a little bit early, but I'm making up for not showing up yesterday. Yesterday was a very busy day. We got a stream of approvals in, and we needed to communicate with our clients the great news and let them know their next steps. So I've decided that I'm going to separate the artist visa information from the entertainment law information because I think that it could get confusing sometimes. So at 12 o'clock, I'm going to do our information sessions on artist visas. And at 2:30, I'm going to do our information sessions on entertainment law. And then 4 o'clock, it'll be creative career advice. So let's get started. This is a question I get asked all the time, and different attorneys will have different interpretations. But I'm pretty conservative, and I want to give you what I think is the best information out there. So, what kind of work can you do on your artist visa? Well, the answer is very complicated because it really depends on how your petition was framed. How your petition was framed means what sort of contracts were included, was the field of endeavor discussed or described by the attorney, are you teaching, are you not teaching, do you want to teach? All of these things need to be established at the beginning of your O1 journey. With my firm, we do this through strategy sessions where I start to identify what you want to do, what you can do, how we can file, how we cannot file. And then we develop that idea. We continue that conversation throughout the course of representation. So it's very, very important to always be honest about what your goals are so that me or your attorney or whoever you're working with can really advise you on whether or not it's something that you can do. So, for example, one of our most recent approvals was somebody that we double-barreled her. That basically means that I filed her with 2 professional titles. I was able to successfully file her with 2 professional titles because she had the evidence and she had the expertise to be able to do that. I also advise this client that we should include teaching contracts so that she can teach during her O1 period. So what can you actually do? So let's take a profession. Let's take performers, for example, and let's flesh this out together. So let's say you file your O1 as a performer and you include traditional performance contracts, right? You might be doing like a cabaret style performance. You might be doing a traditional theater performance, and you might just be doing film work as well. If you file with an agent, remember, you can add additional performances and engagements. That is language straight from the law. But what kind of performances and engagements can you actually add? So if I included an original teaching contract or teaching artist contract, as we call them in my firm, in your original O1 petition, then yes, you can absolutely add additional teaching engagements to your petition. But what if you didn't include that in your original petition? Can you do that? The answer is kind of complicated because technically you will be doing something different than what the scope of the petition was defined as in the original petition. You were approved as a performer, and if you didn't include teaching engagements, then you really weren't approved to do that type of work. Does that make sense? Let's say, for example, you are a designer. And you design all different types of things. You design logos, you do branding literature, and then you get the opportunity to design something in the fashion industry. Can you add that additional performance and engagement to your petition? Well, I can make the successful argument that yes, designing an image or designing a concept which will be applied to a fashion garment is within the realm of design, especially if I defined what a designer is. Now, sometimes we have really complicated titles, like, for example, a visual artist or a multidisciplinary artist or a multimedia artist. These are terms that USAS is not familiar with at all. I mean, it just goes over their head. You really need to define what a multimedia artist is. And I have these types of clients, and they produce gorgeous, interesting, thought-provoking work. But for someone who doesn't really know anything about multimedia arts or a multidisciplinary artist, you've got to define it in the petition. There's no other way of getting around it. I mean, this is how we do it in our firm, and this has been successful for all of our clients. So you really, really, really need to identify at the beginning of your O1 journey what your goals are. Are those goals actually possible? And seek out contracts that will support those future goals, right? If you want to be an actress and a director, but you have no experience directing, it's kind of risky. It's kind of risky to also file as a director, but you want to really sit down and strategize with the person who is working on your O1 petition. Sometimes you can double barrel your petition, so file with 2 professional titles. Sometimes you can file concurrent O1s. It really depends on what the wealth of the evidence and the portfolio is to be able to make that legal assessment, that strategic assessment. So in terms of what types of work can you do on your O1, I want to make it really simple for you. You've got to go to the original petition. And in order to understand the content of the original petition, you've got to collaborate with your attorney, and you really need to understand the implications of certain contracts that you're including. If you are in one of those really abstract professional titles, then you really need to work with your attorney to define that profession within the petition so that USCIS understands what you're doing. So this was a kind of complicated question, but I hope that I clarified certain aspects of it. What my goal for you guys is to understand that you can do a lot of different types of work. You just need to be within the bounds of the law. You need to really understand your profession. You really need to understand the context of your O1, which is defined by your future contract, and also defined by how your professional title is defined within the attorney cover letter. So you've got a lot of elements at play. You've got the I-129, so the technical immigration application. You've got the attorney cover letter, and then you've got the future contracts. So they all work in symbiosis. They all work together. If one is contradicting the other, then you're in trouble. And you really need to, like I said, tighten up those professional titles and define what you're going to be doing. So it was a simple question with a complicated answer, but I feel like I gave you a couple of really good examples to help you understand. The teaching artist example is a critical example. Lots of my clients, they don't think about wanting to teach, and then 1 year into their O1, they want to teach. And if we didn't include those contracts or file as a teaching artist, then for me and how I classify and qualify my clients, it would be probably most likely a no. But every case is different. You've got to talk to an attorney. You've got to figure out the original petition and how you were defined. So just to recap, I'm going to only be doing artist visa information at 12. At 2:30, I'm going to be doing entertainment law information. I'm going to be talking about different contracts that you can utilize to protect your artistry and monetize off your work. And then at 4 o'clock, I'm going to be back with my creative career advice to give you as much information as possible to empower yourselves. If you haven't already followed me on LinkedIn, Facebook, Twitter, you should do so now because we post information every day so that you can really understand your career, you can understand the arts, and you can empower yourself to move forward. I'm Elektra Yao, the artist visa lawyer and the entertainment lawyer, and I will see you later today at 2:30 with our discussion on entertainment law contracts. Bye, everybody.